all the headlines and opinion articles say in this Trump's second term, they are going to yank your green card, maybe on the spot, even at the airport. In this video, you'll learn some truths about the only legal grounds for losing residency, how to handle a Form I-407 demand, and the records that prove you never abandoned your status. So don't ignore this, and you won't miss one tax return, plea deal, or make a long trip abroad that could drop you into removal before you even know it. This video is for all who are rightfully traumatized over the fast and shifting U.S. immigration policies under Donald Trump's administration. I know you're concerned about whether this new Trump can take away your green card, and this is a legitimate worry that many lawful permanent residents are having right now. Hi, I'm Zaira Solano, immigration attorney practicing for 13 years, and I want to give you the complete legal picture, maybe even calm some of your fears so you can make informed decisions about your situation. Let me start with the fundamental truth. Yes, the U.S. government can revoke or take away your green card, but only under specific legal circumstances that have existed for decades. This isn't something new that any particular administration created. The Immigration and Nationality Act, specifically Section 237, outlines all the grounds for removal of a lawful permanent resident, and these have been consistent regardless of which political party is in power. What's important is that you understand that your green card represents lawful permanent resident status, and it comes with both rights and responsibilities. You receive your green card, you entered into a legal relationship with the United States, and that can be terminated if you violate the terms of the relationship. The key point here is that the government cannot simply decide to take away your green card because they feel like it or because of political pressure. There must be legal grounds, and you have the right to defend yourself in immigration court if the government tries to remove you. One of the most common ways that people lose their green cards is through something called abandonment. This happens when you treat your green card like a visitor visa instead of what it actually is. A green card is proof of your permanent residence in the United States. The law presumes that if you're absent from the United States for 1 or more years without obtaining a re-entry permit, you may have abandoned your permanent residence. But this is just a presumption, not an automatic revocation. You have the right to rebut this presumption by showing that you maintained ties to the United States and your absence was temporary. I've seen cases where clients had to leave the United States for extended periods due to family emergencies, medical treatment, or employment situations. And these situations were beyond their control. And in these cases, we were able to successfully argue that they had not abandoned their status because they maintained their intention to return to the United States and their connections here. The factors that immigration judges consider when determining abandonment include whether you maintained a United States address, whether you filed your U.S. tax returns, if you kept U.S. bank accounts, if you maintained family ties in the United States, and whether you took any actions that indicated that you intended to make another country your permanent home. Recently, there have been concerning reports of green card holders being pressured into signing Form I-407 at airports once they return to the United States. This form is called the Record of Abandonment of Lawful Permanent Resident Status, and signing it permanently gives up your green card. I want you to be absolutely clear on this. You should never, I repeat, you should never sign Form I-407 without speaking to an immigration attorney first. Even if a Customs and Border Protection officer tells you that signing is your only option, you have the right to ask to see an immigration judge instead. Yes, this might mean being detained temporarily, but it's better than permanently losing your green card without understanding your options. In many of these airport cases, what's happening is that a CBP officer is questioning a returning permanent resident about their time abroad and concluding that they may have abandoned their status. Rather than placing the permanent resident in removal proceedings where they can defend themselves, they're offering the person to sign an I-407 as a quick solution. But this is often not in your best interests. And if you're ever in this situation, remember you have the right to remain silent, you have the right to an attorney, and the right to have your case heard by an immigration judge. Don't let anyone or any officer pressure you into signing away your rights, into signing away your green card on the spot. Another ground for revocation is if you obtained your green card through fraud or misrepresentation. This can happen years after you received your green card, especially when people apply for citizenship and undergo the naturalization background check. The most common fraud cases I see involve marriage-based green cards where people weren't truthful about their marital history or the nature of their relationship. For example, if you failed to disclose a previous marriage that wasn't properly terminated, or if you entered into a fraudulent marriage solely to obtain immigration benefits. Family-based petitions can also be problematic if you weren't truthful about your relationship to your petitioner. I've seen cases where someone was petitioned as an unmarried child, meaning they were under 21 and not married, but then they married someone before receiving their green card and failed to disclose this change in circumstances. The key thing to understand about fraud cases is that the government must prove that you willfully misrepresented a material fact. Minor mistakes or omissions don't affect your eligibility, and usually they're not enough to revoke your green card. But deliberate lies about facts that would have affected your eligibility are seriously problematic. Even after you become a lawful permanent resident, certain criminal convictions can make you deportable. The Immigration and Nationality Act, Section 237, lists various crimes that can result in removal, including aggravated felonies, crimes involving moral turpitude, drug offenses, and domestic violence crimes. What many people don't realize is that you become deportable even for crimes that seem minor in your state or that resulted with no jail time. For example, simple possession of certain controlled substances can be grounds for deportation even if you only got probation. I've seen cases where people plead guilty to charges years ago without understanding the immigration consequences, only to face deportation when they apply for citizenship or when they return from traveling abroad. This is why it's crucial to always consult an immigration attorney before accepting any criminal plea deal, even if it's for a minor offense. The concept of aggravated felony in immigration law is particularly complex because it includes crimes that aren't necessarily felonies under the state law and aren't clearly aggravated. For example, theft with a sentence of 1 year or more is considered an aggravated felony for immigration purposes, even if you only served a few months in jail. Another ground for revocation that's been in the news recently involves material support to terrorist organizations. This is defined very broadly in immigration law and can include activities that might seem innocent, but the government considers supportive of designated terrorist groups. The challenge with these cases is that the definition of material support is extremely broad. It can include providing money, goods, services, or even just distributing literature for an organization that's later designated as a terrorist. Sometimes people provide the support before the organization was designated as a terrorist organization, but they can still face immigration consequences. These cases often involve complex questions about what organizations are considered terrorist groups and whether someone's activities constituted material support. The government takes these cases very seriously, and they often result in lengthy detention and removal proceedings. If the government tries to revoke your green card, you have the right to defend yourself in immigration court. This is an adversarial proceeding where you can be represented by an attorney, present evidence, call witnesses, and cross-examine the government witnesses. The immigration judge will review all of the evidence and make a determination about whether you should lose your status. Even if there are grounds for removal, you may be eligible for relief that would allow you to keep your green card or adjust another status. Some forms of relief available in removal proceedings, your immigration court case, include cancellation of removal for permanent residence, asylum, adjustment of status, and various waivers depending on your situation. Each case is unique, and the availability of relief depends on the specific facts and the grounds of removal. Given all of this, what can you do to protect your green card status? First, I want you to maintain your permanent residence in the United States. This means living here, filing taxes here, keeping U.S. bank accounts here, and not spending extended periods abroad without proper documentation. If you need to travel outside the United States for more than 1 year, apply for a re-entry permit before you leave the United States. This document shows that you obtained permission from the government for your extended absence and helps establish that you did not intend to abandon your status. Keep good records of your time in the United States and your connections here. This includes lease agreements, employment records, tax returns, bank statements, and any other documents that show your ongoing ties to the United States. Be completely honest on all immigration forms and applications. If you made mistakes in the past, it's better to address them proactively with an attorney than to hope they won't be discovered later. If you have any criminal history, get a comprehensive immigration analysis of your criminal convictions before traveling or applying for citizenship. What might seem like an old, minor conviction could have serious immigration consequences today. I want to emphasize that while the government can revoke your green card status under certain circumstances, you have the rights and options for defending yourself. The immigration system, while complex, does provide due process protections for lawful permanent residents. And the most important thing you can do is stay informed about your rights and obligations as a permanent resident. Don't let fear prevent you from traveling or living your life. But do be smart about understanding the legal landscape. If you're eligible for citizenship, seriously consider applying. U.S. citizens cannot be deported and cannot have their status revoked except in extremely rare cases involving fraud in the naturalization process itself. Now that you understand the legal grounds for your green card revocation and your rights as a permanent resident, you're better equipped to protect your status and make informed decisions about your future in the United States. The immigration system is complex, and every case is unique. If you have concerns about your status for eligibility for citizenship, the best thing you can do is consult with an experienced immigration attorney who can review your specific situation and provide you with personalized advice. Remember, knowledge is power in immigration law. And by understanding your rights and obligations, you can take proactive steps to protect your status in the United States and build a secure future in this country. Speaking of being prepared and protecting your rights, one of the most crucial moments in any immigration case is the interview process. Whether you're applying for a visa, a green card, or citizenship, the interview can make or break your case. That's why my next video is absolutely essential that you view it. I'm going to walk you through exactly what to expect in your visa or green card interview in 2025, including the questions they're asking now, how to prepare your documents, and the mistakes that could cost you your case. This isn't just helpful information, it's critical preparation that could determine whether you achieve your immigration goals or you face unnecessary delays and complications, wasted time, wasted money. I've seen too many well-qualified applicants stumble into interviews simply because they didn't know what to expect. Don't let that happen to you. See you there.